Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my supreme co-host, Brett. And in a very anticipated conversation, we have with us today the wonderful Allison and Bob Motta from Defense Diaries. Welcome, guys.
So excited to see you guys. It's been a minute.
Yeah.
And can I just say, Bob, you're like newscaster voice that you go into when it gets serious. I love it.
Yeah.
I love it. It's just so smooth. Or it could be like smooth jazz.
Right.
Oh, it is smooth jazz.
That's like my scripted. Like I do my scripted and like my radio voice. You know what I mean?
Well, no, but at home, when when one of the kids or I, like they say, oh, well, you just use your podcaster voice. He's just like, what do you mean? My voice, I don't do a different voice. That is my voice. So.
Oh, Bob, you do a different voice. I'm not saying it's bad, but it might be a little weird if you're like, Allie, it's time to do the dishes.
Is it time to go to the amusement park? Let's go, kids.
Oh my goodness.
I love it.
So we're here today to talk about how to get a refund when your hotel room catches on fire and you are sent running into the stairwell. And I'm so glad that we have a personal experience from Bob Motta to be able to talk here tonight for probably about 2 to 3 hours.
Easy.
Just kidding. Just kidding. We are obviously here because today was the Indiana Supreme Court oral argument in the Delphi murders case. But the litigant was not Richard Allen. Rather, his former attorneys, Brad Rosie and Andrew Baldwin, have asked for extreme remedy from the Indiana Supreme Court for 3 specific things. Number 1, to be reinstated as Richard Allen's attorneys after Judge Gull at the trial level removed them. Number 2, to have the Supreme Court set Richard Allen's trial within 70 days. And number 3, to remove Judge Gull. And today that oral argument happened. And joking aside, Bob really is in Indiana and did sit in at the oral arguments. So, Bob, thanks for being with us here today. And Allie, I know you were watching on YouTube and giving live commentary, and a lot happened. We're just prefacing for everyone what we're here about today. And I look forward to this discussion. So kind of we'll just start with you, Bob. First of all, after that fire alarm went off, what time did you have to get to the court? And, what was the scene around the court?
It was busy as you'd expect it to be. And it's in the state building. The Supreme Court room that they use is in the state building. So you have all of the hullabaloo of all the other functions of government going on in there at the same time. So it was packed in there. They had like probably 400 kids like there for some kind of award ceremony. We could hear them cheering outside of the actual courtroom. It was muted. But I got there. I was fortunate enough to get a reserve seat, so I didn't have to do the line. So I was lucky in that sense. So I got over there about 10 and just kind of hung out. And, and when you go to something like that, and you guys, I listened to your legal briefs the other day where you're kind of explaining what people can expect with this type of hearing. It's nothing like watching a trial. It's a very different experience. And, when you're law nerds like we are, it's like the pinnacle. It's like you walk in and the trappings of the courtroom are so beautiful and austere, and you can feel the weight of it in a different way than it's typical in our state courtrooms where you're just at trial. I mean, obviously, if we're on trial, that's different. But if I'm walking in for a status hearing or even a motion, like, you just don't get that feeling often, So I loved it. I loved every second of it. I just love that everyone in that room, the justices, the lawyers, understand the weight of it, and they treat it with the respect it deserves, because it's the embodiment of our legal system encapsulated in a room. And it's a beautiful thing. And it's so compelling, it's just so compelling.
Was there a lot of press there? Was it covered up
Ton
with
of
cameras
press.
and everything, or?
Ton of press. Yeah, they were lined up, and they carved out some room for pretty much a good majority of the press. The seating was more than I anticipated, because I was worried going in, because this reserve thing I didn't even know. My plan was to go and get in line, and do the work. And Kara had reached out to me because her husband couldn't make it. And she's one of the ones who had drafted the OA, because I had gotten friendly with her, and she's like, "Do you want to?" And she's like, "Want to come?" I'm like, "Yeah, yes, please." No line.
Oh, that's
Yes.
so cool. You didn't know, and you answered the question that I think a lot of people had. How does one get reserved seats at the Supreme Court? But how many people had reserved seats, and how many people do you think were watching from the gallery?
I think there were approximately, I'd say, best guess, about 60 in the gallery total. So the first two rows they had reserved, and they were probably about, I'd say, 10 across. So I think it was like 10 across. So it was 10 on each side of the aisle, and it went back 6 rows, maybe seven. But there was a lot of press there. The families came. The families were there. Of course, Rick Allen wasn't there. Kathy wasn't there. Judge Gull was not there. Apparently, she was on a murder trial. And then the state, so the state had, significant others come, like everybody, like Kara's husband was there. He ended up coming. So somebody must have dumped out, man. I wasn't asking any questions.
I think it was Richard Allen's wife, because
I think that's right. I think it was Kathy, because she was upset because she had only gotten one seat, and she kind of wanted a support system there. So she ended
But Bob,
up.
you actually make a really great point there that Richard Allen wasn't there and Judge Gull wasn't there. I think that's important for people to know, because we've watched a lot of these trials, and obviously every time there was a hearing that involved Richard Allen at the district court, Richard Allen, sits at the table and is present. But appellate hearings obviously are different. We know this, that their legal arguments and your representation is there. And honestly, in my experience, whenever I do appellate work, my client is not there, because it's kind of one step removed, right? We've always said it's on the record. It is not this, judging someone's credibility by their faces and whatnot. So were you expecting Judge Gull to be there, or did you know that she was not going to be there?
No, I heard she wasn't coming a couple days ahead of time. And interestingly, predecessor counsel wasn't there. So that kind of surprised me a little bit. I mean,
she had two lawyers before? Is that what you mean?
No, yeah, I mean subsequent counsel, not predecessor counsel. Yeah, both Andy and Brad were there, but they weren't going to go. Kara had to talk them into it, because Andy was saying, "Oh, I don't like, it's too much for me." I think ultimately it was important that they be there. I mean, they were really the kind of the impetus of the whole thing. So I think it was important for them to be there, as far as Judge Gull goes. But we'll get into it. It was a fascinating day. It really was.
I was just going to set out the parameters for, I'm talking through this because I think a lot of people watching have watched it, but a lot of people have not watched it. So we're not going to give things away. We're going to walk through it. But unlike at the district court level, there are time restrictions. And so today's argument was supposed to take an hour, but it was interesting because it's obviously the movement, in this case, attorneys for former defense counsel, gets to go first because it's their, moving. And then the representation for Judge Gull and the state got to split time, and then there's a rebuttal. And it really stayed pretty much within that hour. They had those little green lights that then turned read when they ran out of time. And I was actually impressed that they stayed within those time limits. But as we'll get into it, a lot of words were said per minute within that hour.
A lot of words from everybody.
So obviously, you know, both your show and our show, we've talked a lot about this. I think everybody knows where we sort of stood on it. And I got to imagine, and I'm interested in Ali because we've heard enough of you, Bob. I got to imagine as you were watching sort of how it developed that you felt good about Richard Allen and his former attorney's chances. I mean, we talked about a little bit on our show that a lot of times you can't tell from the questions the court's asking how they're going to come out. This one, it seemed, I mean, about even, you know, the person who was representing Richard Allen / prior counsel, you know, when he got finished, I thought, well, you know, they asked him some tough questions, but you know, it seems like they buy what he's selling. But then when the counsel for Judge Gold and especially the counsel for the state got up, it was just like a massacre. It just felt like this is not going well at all for them. So y'all had to feel good sort of when it wrapped up.
Well, yeah, because we were doing the live. So one of the questions that someone asked was, how many of the judges did I think were going to put Richard Allen back on? I was like, all of them. To me, there was never a question. I mean, it was a non-issue. There was no way that the Supreme Court was going to let a structural error like that sit. And I know, Brett, at least from Bob telling me, you had some questions about whether when they were court appointed, that the law was as firm on, you know, removing a court appointed attorney, which it's definitely at a point. I said to Bob, I'm confused. Why didn't they appeal the order from when they entered their appearance pro bono? And I know, Alice, you want people to understand. So there were two aspects. There was, first, these were the court-appointed lawyers. And you don't have a right to a court-appointed lawyer of choice. So you get who you get. When you hire private attorney, you have the right to your counsel of choice, to be represented by the person who you choose. And that person cannot be removed very easily, but surely not the way this happened, without creating what the law calls a structural error. And it's the most serious error that can happen where there is no balancing. There is no, well, were they prejudiced? Because typically in the law, no matter how bad a trial goes, no matter what the errors are, the end question ends with a balancing. Well, you know what, buddy? The evidence is really strong against you. You're clearly guilty. You weren't prejudiced no matter how bad it was. So when you have a structural error, there's no balancing, there's no considering. That's it. The end. Go back and do it. So as soon as she mentioned the Gonzalez case, I was like, all right, boom, it's done, because I know that's the case that speaks to structural error in that issue. And then we did have some justices asking about the right to continuing counsel, which was sort of what the issue was, where that kind of Bob would tell me your position and I would say, no. There's some law to support that you have your continuing right, but it's clearly not as black and white as your right to counsel of choice. So I was surprised when they did not include the order of denying them the ability to be private counsel when they agreed to do that, because I thought that was their strongest argument. They did have a strategic reason for doing it that way, but I was concerned because, as Brett, I guess, has pointed out before, the law on continuing counsel is not as black and white.
I don't think they wanted to go back and do it for free. I think that was one of their reasons.
I think that was clear from rebuttal.
Well, but that was
Yeah,
one
like,
of the things. Yeah, like, but that was one of the things where, like, when it was all going down, and you guys were like, well, the thought is, and Brett, I'm like with you theoretically, because theoretically it's the absolute truth. Defense attorneys use the speedy is leverage all the time. It's like we use it as a strategic move constantly. In this particular scenario, I happen to know that they were serious. They were ready to go to trial. And when Lehman argued it, when he talked about that aspect of what I'm saying strategically, for us, when we love, and it's, we love trying to be able to catch you guys off guard. In a case like this, They had the sense that McClelland wasn't ready, and they were right about that. I mean, we have McClelland at the I don't know if it was the city board meeting, but like having to beg for $5,000 so they get an assistant to help him, and he's flat out saying, he's like, if I don't get this money, I'm never getting a conviction on this case because I can't do all the work by myself. You know what I mean? So it wasn't a matter of is he a good lawyer or not. It was a matter of it's a very small office over there, and he doesn't have the kind of help that you need for a case of this magnitude. He didn't have his now second chair enter his appearance until October 31st. Or no, it was the 19th, whenever the in chambers was. Because that's
have
when
to
he
tell people who McClelland is. I think most of our collective people all know, but Nick McClelland is, of course, the prosecutor.
It might be, and certainly asking for resources is always a thing both defense counsel and prosecutors are needing, but I don't think it necessarily means that he was asking for resources because the investigation was incomplete. Maybe that is the case. I only mean that when you're gearing up for trial, you typically don't put a second chair or a third chair on until it's on really time, game time for trial, just because, like you said, caseloads are so high, small offices, everyone's doing their own trials until it's like, no, we got to buckle down for this trial. I only mention that because it's absolutely, I think that he probably needed more help, but I'm not sure that means he wasn't finished with the investigation, because we all know the sheer number of exhibits in this case is massive. I've had to do, thousands of exhibits for it's a full-time job to like properly redact and do the administrative side of getting ready for trial, which has nothing to do with investigations.
That's 100% what it was. That's what he said. They're talking about 170 witnesses, like just preparing the subpoenas and tracking everybody down like that. It wasn't really anything having to do with, I think that he knows the case. I think he knows the evidence backwards and forwards, but it's all the moving parts to be able to prepare for a trial like that. Is, you know what I mean? It's a massive amount of work. I mean, we've been on that side of it with the Garcia case. It was overwhelming. And we had two of our young associates and a third intern, and my father and my PI was living with us. He was our like absolute go-to. Like he drove us back and forth to court, did the cooking in the morning. We get up. It was like some kind of weird logging camp. Like we all get up, eat breakfast. He had this van that I always unaffectionately called the pedo van. I'm like, this looks like a pedo van, man. I'm like, what is it? But like, and he drive us back and forth to the courtroom, pick us up. So he was indispensable for us, but just all of the logistics and the administrative side of preparing for a trial, which I'm always trying to tell people there's so much to do. So that's where it was. And as far as Judge Gull went, my position with her was that she just wasn't running the case. Forget about the docket stuff. She just had pending motions. And look, she's in a much larger county in Allen with a lot of serious crime. She's got a crammed docket, so it's not an easy gig for her at all, and she's trying to come back. Because when she couldn't get to the memo, you just knew. And she's admitting on the record, she's like, I haven't even finished reading the memo. And I haven't looked at any of my clerks haven't even finished going through the exhibits, which are voluminous. You know what I mean? And then there's the pending motion in limine for the unspent casing that they're trying to keep out. So those two, like, were floating for months without even a date being set. It shows you. So if we assume, and I have no reason to believe that it's not, that they were authentic in terms of saying, we are going to trial, we're making a speedy demand right after you enter the order with the discovery deadline. Like, people were like, well, because they admitted in court today that they had the speedy demand in writing since August. And it makes sense.
Can I ask you a question about that, about the speedy demand? So at least where we practice, you can make a speedy trial demand, but if you're also filing motions, like a motion for Frank's hearing or motion to suppress, anything like that, that stays the deadline for the speedy trial. The clock doesn't run. So even if they had filed the speedy trial motion, until she rules on the Frank's motion, wouldn't it kind of not have any effect anyway?
That's the way it is where we practice as well. It's everywhere that I've practiced. It's been that you have your speedy trial, right? But if you file a motion, I mean, I've been struggling with that since the first day I walked into a courthouse, because I'm like right now I have a federal case going. I'm like, well, they haven't gotten me all the discovery. So I have to file a motion to force them to get discovery, but my clock has to stop because they're not giving me what I need, or I need something additional. So that has always been an issue. But I don't know if Bob, if you do know, but it sounds like they've got these two different aspects. It's like they have this, you make a demand, you get it in 70 days. So I think during that 70 days, you can be doing whatever you want, but I don't really know for sure. Do you know specifically, babe?
No, I don't. And, the question that raises is if it's the judge's delay. I mean, you can't really put it on the attorneys, but it's I'm so like when she's admitting on the record, a year into the case that she hasn't read the motion that was filed at that point, a month and a half prior, it's like, for me, it was just unusual. Like when we file a motion, when Ali's got a motion on file, we file with, a notice of motion and we're picking a date. Now the judge, of course, may change that, but we're going in and setting a date in order to get, the briefing schedule done. And then Ali's going in and getting the date for hearing. You know what I mean? So it was very unusual the whole way that she was running it.
So I think that's that's very helpful to hear, that our jurisdictions are at least similar in how they run that. I think what Brett was getting at is if they really wanted to, catch the prosecution on their heels, as today's lawyer kept saying, they could, by basically not filing these repeated motions and not filing the speedy trial demand. I'm not saying that's necessarily their tactic, because certainly there are legal motions that need to be filed and need to be ruled upon. But I've certainly had cases, and I'm sure you've had too, where certain things are happening, either like the person keeps sitting in prison and the defense counsel's, look, let's cut this crap. Let's go to trial because I can't change his mind. You're not going to change your mind. We can file all these motions to compel. We can have discovery fights, or we can withdraw our pending motions and go to trial in a month, or even sooner, whatever they want. I've had that situation where it's usually a more limited case than this one. And I think Brett's point is they're trying to have their cake and eat it too, it seems. We want the speedy demand trial, but we never filed for it. But also we keep filing these motions that are going to, by virtue, delay whatever we're asking for.
I assume there'll be a motion to suppress at some point.
I mean, I would think so.
Beyond the Franks
technically
motion.
There is. They convert. Remember, the original motion that turned into was really a motion to suppress the search at Allen's home. So that's out there already. I mean, I get what you're saying, but from the perspective of, well, look, like you said, there's motions they have to file. I mean, and that's the thing. The tenacity by which you use the speedy trial is a double-edged sword, very much so, because it could easily pierce us just as easily as it does you, because it shortens the period of time. Even though we don't have the burden, we still have to prepare for the case, so we're working on shorter time as well. You know what I mean? So it's always a scary proposition. Like on Garcia, I always sit here and I'm like, oh man, I still ruminate about we should have gone with the speedy on that, because they pulled so much evidence post arrest. Like that thing went on for 3 years. And
by the way, for people that don't know, Bob's talking about a serial killer case in Nebraska where we represented an accused serial killer. And there was a football field, literally. I don't know how I didn't take a picture, but it got to the point where they were like, fine, we're going to produce it to y'all and you can figure out what you don't have. And I had a football field. Literally. So
it had all the physical, they had a room with all the physical evidence, like everything. It was a lot.
I was just going to say, I agree with Alice, but for a different reason, because I don't understand the whole, I think during that 70 days, they can be doing whatever. But I noted if he really wanted to catch them on their heels on that, why include so much detail in the Franks motion?
Well, why have a 1,000-page motion, right? Because you can't, it takes time to read that. There are certain ways that you can file motions. We do this all the time, especially in motions in limine right before trial. We file 3-page motions because we want a ruling before we go to trial. And we don't actually want those issues pending. So we cut to the heart of the issue. obviously there was a lot more. You probably could have said that in a lot fewer pages, probably, a tenth of that. You have your choices, but you know that that's going to delay. So it just seems like they're saying one thing, but maybe they actually did not want to move as quickly as they're claiming now.
I think that there's a bit of Andy Baldwin drafted the memo. So, and remember, Brad and Andy are not in a public defender's office. They're both private attorneys that were appointed as PDs on this case. They both have their own practices in separate towns. So in terms of I don't necessarily know if Brad knew it was going to be 136 pages long.
But Bob, if you want to surprise the state, you don't put all your secrets in the memo right before you go. I mean, that was like my issue. I'm like, well,
I agree.
We've been pretty public about that. I think it's because it was a great way to get your story out there. But here's the thing, you can still do that. Get your story out there if that's what you want, but then withdraw the motion and say, never mind, judge, let's go to trial because it's taking you too long. They can do that. You can kind of have your cake and eat it too. I don't think you should do that. But if what they wanted to do was to get their theory out there, it's on the public docket.
I agree. And that would have been the power move, withdraw it. But then you just go back and file the 6 pages of the 136. That was the actual Frank's motion.
Sure. Right, I agree with you.
That would have been
I just think strategically that would get you your cake and you get to eat it too.
Yeah, exactly. It's clearly very, very transparent what you're doing. You're not fooling anybody with that move. That's for certain. And Gull was already irritated with them,
Yeah, she was going to kick him off the case anyway, so you might as well do it, right? And I hate to jump ahead, but in case if anybody doesn't know this, I don't know if this happens more often in state court than it does in federal court, but they had the oral argument today, and actually I talked about an instance where we did this once when I was clerking, so I guess it does happen. But they had the oral argument today, and then 2 hours later, they released an order without an opinion, and opinion's coming later, that basically said a majority of the court agrees to reinstate the attorneys, and then unanimously not going to grant the motion to remove, not going to grant the motion to set the trial in 70 days. Now, I assume that the reason, and I guess we'll know this whenever the opinion comes out, and it might be a while because I suppose there probably will be dissents given the wording. I assume that the reason they did not grant the removal and the speedy trial is because this was mandamus, and those weren't really proper requests at this time. So it would seem to me the defense is not foreclosed from moving for one or both of those at the trial court level. Do you think the defense will now, the old defense is new again, do you think they'll walk in on Monday or whatever and file that speedy trial demand that they've been talking about?
No, I don't. I think that there's going to be some housekeeping that has to be done.
In a week, do you think they'll file the speedy trial demand?
So they already have, Rosie filed a motion for her to recuse her. So that's already been filed. During the whole hullabaloo, he filed it. So it's still pending. So that's going to have to get dealt with. And I wanted to ask you guys what your opinion on it was with respect, because Allison and I were debating it. I was sitting at lunch with Mark and Karen. I'm like, well, because I thought it was going to go down exactly what happened. I thought that they would reappoint them. I thought Gull would stay on. And I thought, to me, the 70-day thing was like, that's not their purview. That's not their problem. And like Allison was like, why? Like, why do you need the court to order that? Just, put your motion in, put your speedy demand in. Like, what do you need the court to do that for? So I just think that they're going to, if I were them, I would wait it out, make sure there is a distinct possibility that Judge Gull is going to sua sponte follow through with her thing. She
may as in recuse herself.
No, she may follow through with her and have a hearing with regards to whether or not they were grossly negligent. She could absolutely.
That's gonna be really interesting. Obviously, we don't have an opinion yet. No. I don't disagree with you. It's gonna be really interesting what the reasons are, because at the oral argument, which I know we haven't talked a ton about, a lot of the questioning to Rosie and Baldwin's attorney was about should we just remand this for the record? We know what she's going to say, but there isn't a record. You're correct. But then it was interesting because when Judge Gold's representative stood up, all the questioning was about, should we reach the merits of it? So that's going to be really interesting about what the order says. I thought you were going to say, if she's on the case, whether she would choose to recuse, because we are in an interesting situation. The order, 2 paragraphs long. There's not much there except the kind of, bomb of an order that they are now reinstated, and none of the other lower court proceedings are stayed. So you're right. Come tomorrow, there could be things going on, but no one really exactly knows what posture everyone's in. There are pending motions from both new counsel as well as former now again counsel, and it is a bit in the air and unusual to issue an order like this without some sort of direction as to what the court was thinking. And I think this creates a bit of a mess tomorrow.
There are 2 possible ways they could have gone on this. It was funny. Ali was talking about when she knew that they were going to win. I knew they were going to win when one of the lawyers was talking about wheat.
When the chief judge said, I don't care about the Supreme Court case.
The justice was like, okay, wheat. What's your other case? And it's like, okay.
I think all of us on this call were like, well, if you don't like that case.
I had that happen once.
I'm going to send you the wheat meme. It's so good. It's the Chief Justice, and it's like wheat intolerant, and it's got a picture.
Yeah.
Man,
she was definitely like out there with a swing blade, chopping down the wheat.
Truthfully, at first I thought the chief judge. I thought her questioning was very incisive. It was it was a hot bench. So there were 5 Supreme Court justices, and they all had a lot of airtime in terms of conversation. I can't believe they didn't go over time, to be completely honest. So kudos to them for sticking with
that.
The
Was
time.
A hot.
When we say hot bench, for those of you who may be new to both of our podcasts, it means that the judges are questioning like crazy. And truthfully, I thought it was hot when Rosie and Baldwin's attorney was going, but man, it like ramped up to, multiple degrees higher when it was the respondents.
There was one point where the Chief Justice was asking, I think it was of the state, and she basically said, why not just send it back? They can have a hearing and do it again the right way or something like that. And it really leads to the question of, when they issue this opinion, are they going to say basically in Indiana, you just have a broader right to continuity of counsel. We're just going to find a broader right, and she could not remove them for this reason. Even if she'd have had a hearing and that's the way it is, in which case they have to stay on. But if it's just, well, maybe she could remove them, but this is a terrible record and she should have had a hearing and she didn't have a hearing, and so therefore on this record we're reinstating them. Those are vastly different things that we have no idea.
Which we can't tell from today's order.
Yeah, right. So, I think it would be really bold of her to say, okay, fine, we're going to have an evidentiary hearing, when, for all she knows, they decided against her on a much sort of more fundamental reason.
And also, I think it would be too soon for her to recuse as well, because she doesn't know what exactly was the basis for what the Supreme Court wants her to do. Is it just to allow them on? And they can be very clear if they're like, we reached the merits, because they talked a lot about that. They said, should we reach the merits here? We don't know if they've reached the merits. And if they have reached the merits and they're essentially directing her not to remove them, no matter what record she thinks she has, then she's in a position of what to do with the recusal motion. But if it's just about having the hearing, and if they kind of touch upon the merits and are like, this is all very concerning, et cetera, and had the court properly had the record made, this would fall within the discretionary duty of the judge, then no, that would put the cart before the horse to recuse herself. There's no need to do that until she has a hearing. And then, the appellate process can continue. All to say is, people who think that today's order that came out shockingly fast did something big, but it left, I think, a lot more questions than answers.
Now, given how fast it came out, maybe they're already working on the opinion and have been working on the opinions for the last month. They might have known going in, we're 4-1, we're 3-2 or whatever.
Yeah. The word on the street is 2 weeks.
How many?
2 weeks?
2 weeks. It's going to be a quick
Which
turnaround.
Is kind of a long time in a 70-day trial, if you really wanted a 70-day trial.
I honestly don't think that I don't think they're going to make the demand now. I think that they're smart enough to know that, because they're both highly, but I'm just telling you that they're both good attorneys. Brad Rosie's
no, they have great reputations. I think even the justice or the the litigant for Judge Gull said, I have a question
They're
for
highly
you,
competent.
Oh, I love
highly
that.
competent.
Highly
Except
competent in
in
other
certain situations.
circumstances.
It was such a glorious moment. I was just sitting there with a shitty.
So obviously, if the order came out within hours of the end of the hearing, so as we know, probably what happened is they adjourned and the justices probably went back to a conference room and did a preliminary vote, and then they issued out this order. But that was a fast order. So I tend to think they probably had made up their minds before they even had oral argument. Why have oral argument if you know how you're going to come out? And why not just save everyone the time and the media circus and not issue this like kind of quick order that doesn't explain their reasoning and wait the additional 2 weeks and release the whole opinion with their reasoning? So why have oral argument if I think they already made up their minds?
Yeah,
It's a good question. It's a good
No,
question.
your
I don't
turn.
know.
It's been your turn.
I don't know if it's just because, you want everyone to feel like they had the opportunity to be heard, which is often an issue under the law, people wanting to be heard.
Can I cut in really quick there to ask you a follow-up on that? I agree with you, but I tend to find in my experience that courts want people the opportunity to be heard if they're going to rule against them. So in this case, it would be that Rosie and Baldwin had the opportunity to be heard because below maybe they haven't been heard. But if they were going to rule for them, why?
Yeah, I don't know. Maybe it was just because I can answer the second part, I think, more easily. And I think it's because you cannot remove somebody's lawyer. So I'm telling you right now, without telling you why, put the lawyers back. And I think that they consider it to be such a serious and such a black and white issue that no matter what other thing we have to say in this opinion, what we know for sure is the lawyers have to go back, is why they did that so quickly. And we actually had, thankfully, because I've been working on a post-conviction petition and had some other things going on, Travis had sent me some information. Included in that was that this court is known to do that, to issue the writ really quickly and then say an opinion will follow. So I knew that was, a possibility of something they could do. I was surprised it came back as quick as it did, but they may have been amongst themselves. And I don't know, maybe you guys know more because,
Well, I can tell you, if you listen to the argument, which I know we all did, I mean, they really focused a lot on the delay and the cause of the delay. I mean, that was a big sticking point for all five of them up there in terms of the delay that this caused, so I think in terms of them saying, okay, because they unequivocally knew before arguments that they were reinstating them, and they didn't mention Gull. Like the issue of Gull wasn't even broached at all. I mean, they never talked about.
You're right about that. Yeah, you're right. They never talked about the Judge Gull.
Because they'd already decided that too.
So I may sound like I'm recycling arguments as before, but if this was such a necessary remedy that they had to rush out this order within hours of the courtroom closing, they didn't have to have argument.
So that's what I was going to ask you.
I mean, I think that's really interesting. Remember, there was another mandamus writ filed with respect to the unsealing of documents, which they ruled upon much more quickly than this one because they had to wait through the holidays. They had to set oral argument, which, as you know, you call the litigants and you say, are you available this week? Are you available this week? And then they had to get it set up for argument. So if, in fact, we are talking about we cannot wait another day, we cannot let another night go by because someone's constitutional rights are violated. Right. You would think that they do this, months ago.
Alice, is it possible that the justices, knowing they had certain disagreements amongst themselves, do it for their purposes of their dissent and of their opinion and have that conversation there?
Great question. So what you're touching upon is that sometimes, and we see this more at the Supreme Court because of the 9 justices and there's a lot of differing opinions and jurisprudences, is that you'll use questioning at oral argument to advocate that justice's own opinion about how the case should go in order to sway your fellow justices. In this case, they didn't seem to be on opposite sides, which is what's so weird. So it didn't seem like, one of them was asking questions in a way to pose hypotheticals that would reach another justice's concern. So yes, that is a tactic for justices. I didn't see that here, but I do have a theory as to why they had oral argument. One of them may be that they felt strongly about the fact that below, Rosie and Baldwin did not have a right to be heard. And so They did not want to essentially chastise Judge Gull for doing that if they weren't going to do the same thing, because they recognize that the entire nation is watching them, and the rest of the nation may not know that you can have lots of orders from a Supreme Court with no oral argument. That's slight. Secondary, it might just be because they know this is probably one of the most watched cases in the nation, and maybe they wanted it to be transparent what they were doing. Or maybe they wanted people to understand how oral arguments at Supreme Court go. Or maybe they just felt pressure that if they did anything short of an oral argument, they would come under attack, that somehow justice is done behind a veil, even though they were doing something that was providing the relief that was being asked.
I think it was
of
a
them.
combination of all of those things, to be honest.
I also think there's the aspect of sort of court management that the Supreme Court of a state has to be involved in. And one thing that I think came across very clear, which, I mean, I think you can remove a lawyer for gross negligence. Put that out there. But the thing that we always criticize Judge Gull for is have the hearing, make the record, write the opinion. And I think the one thing that definitely came across to anyone watching this today, and any judge who's watching it, any lower court judge in Indiana, have the hearing.
Have the hearing.
Develop the record. There was a very clear, the chief was all about that. She couldn't have had it
that day, though. And we've disputed this point between you and I, brother.
Well, then have it the next day. I mean, have it a week later, whenever.
Right. I mean, give him a week. She's got to give him a little time to prep, to get witnesses there. You know what I mean? But yeah, have the hearing. Like, that was always my point. Actually make the motion sua sponte. Don't insinuate it. You know, yeah. Well, like that line that she told Baldwin, he's I'm not good at reading the forest through trees, or and she's like, you're a lawyer. That's what you do for a living. You know, it's no. File the motion. Let them know. Give notice to the defendant. It's not about Baldwin and Rosie. It's about Richard Allen. On the 19th, the man was never even brought into the courtroom to hear that his counsel had withdrawn. He was not sitting in the courtroom. That's ridiculous. It's unheard of. She was playing on tilt, man. It was like she was so upset. Like that whole thing, the way it went down. And I watched it develop. I was sitting in the courtroom when just the parade of officers walk in and sit in the jury box and just sit there for an hour. It's like, I'm granting your motion for the camera. Oh, and Mr. Rosie, I just want to let you know that was your motion. Be careful what you wish for, type thing. And then she goes, and I mean, we've seen the transcript at this point, what happened back there, because everybody's saying, oh, she's offering them an olive branch. She's like a graceful bow out. No, that was like, from a defense attorney's perspective, that was an absolute ambush in terms of, yeah, they may have known, but if you're going to do it, give proper notice. Like due process just requires it. It was one of those.
It's not an ambush. I mean, I'm just saying.
Oh, it was totally an ambush. It was absolutely an ambush.
I think it was very interesting that you say that, because even Rosie and Baldwin's own attorney kind of went through the timeline of, he's like, there's been a lot of lawyering, of everything that's been happening. So whether you think, several weeks is ambush or not,
but it's not actual notice of a hearing, Alice.
There was an email that said, I'm going to have a hearing, and I'm telling you, I mean, he literally said that today. His attorney said, their attorneys said that today. They had an email exchange. I agree with you that the email exchange seemed to come after a phone conversation that wasn't on the record. Look, we've been very critical about the fact that a lot of this has happened not on the record, and we have to have everything on the record. That's not how I practice law. When our judges forget to do something like that, we stop all conversation and ask court reporters to come in to have the, in chambers conversation. So we are very critical about that. But in terms of no notice, maybe not on the official docket, but there was certainly conversation between the judge and the parties about what she was leaning towards and that she was going to have a hearing.
But leaning towards isn't enough.
No. Just the hearing. What she was leaning towards.
That's what I mean. If you're going to have the hearing, give them proper notice.
Then why did Rosie and Baldwin?
Because they're not idiots.
No.
Surely, Bob,
why did they hire an attorney?
She'd have stuck something on the docket.
Idiots. They knew.
So they knew.
Well, she knew.
That's not proper notice.
Wait. How about I want to ask this? Something I don't think the prosecutors can deny. In order to have proper notice, you need to have the foundation of what is going to be addressed at you. You can't just know I have a plan to do something that in the law requires you to lay out the factors and the formula by which you are doing it so that you can intelligently respond to the issues. So notice I'm going to do something, even if I know what the end result is, without knowing what factors you're relying on to get there or what standard you are using, and being able to call witnesses to address each of them. Because if I understand correctly, when she said we're going to have a hearing, they were responding on the Frank's motion, on this, on what? Yes, obviously they were suspicious enough to get a lawyer, but without knowing precisely laid out the standard the judge is using and what she's proposing to do about it. I don't know how you can have witnesses to confront that.
And look, I think what she should have done is she should have given them 2 weeks. They should have had a full hearing. She should have destroyed them in the hearing. They should have put on all the evidence. It should have been an absolute public just beat down of these 2 lawyers. And then maybe this hearing today goes differently. I think the fact that they not only hired a lawyer but filed a memorandum shows that they knew what they were arguing about. I think she totally messed this up. I think she tried to save some time. If you want to be charitable to her, not embarrass them in front of everyone.
I think she was also trying to do a solid to them. I think it was a complete error for her to do that. But I'm just saying, I think she messed up there because I think she didn't want to embarrass them publicly.
If they had just withdrawn and gone away, I mean, if it really was the most embarrassing day of Baldwin's life or whatever it was he said, I mean, Baldwin didn't seem like he was that upset. Rosie seemed like he was totally angry.
Baldwin was destroyed, but like Brad's an aggressive lawyer. Baldwin, like in all pre-trial, like, so Baldwin is way more laid back. Brad's super aggressive. Like he's like a real A-type person.
And that comes across.
Yeah. And it does. But like it trial, what Andy does is he gets aggressive. Like
right.
The kind of good cop, bad cop it in a sense. And the fact of the matter is when you have a situation like that, again, like everything that Allison was saying, but when she finally gives them actual notice as to what the points, exactly what Allison was saying, was that morning. So they had no opportunity to be able to prepare anything. And I just disagree with you guys completely in terms of anything that they did even being close to being gross negligence.
So we have not. I mean, first of all, we agree on the notice issue. We think that was a complete mess up. But this was mentioned at the oral argument today, and I think it's a valid point to discuss, is that when we have been surprised in court, and it's happened to all 4 of us all the time, because judges do this from time to time, or a new piece of information comes up, or someone testifies to something no one knew about, and we're all caught flat-footed. What do? You call for a recess or a continuance of the hearing so that you can do your proper investigation, call the right witnesses, and they didn't. They didn't do that there. Now, you could say that because it was such a heated moment, they knew how the judge was going to come out, but that was the whole point in the oral argument today that the justices did kind of pound on, which is that, no, the hearing didn't happen, so we actually don't know how it would have come out ultimately. It probably would have gone, even the Judge Gull's attorney conceded, probably would have gone the same way, that she would have had the hearing and removed them. But they didn't take any of the actions you typically do as an attorney to buy that time so you can properly respond to the legal standard and the allegations that you now know are going to be alleged against you.
So he knew that the legal standard alleged against him. I don't know. Are you guys saying that exists? That there's some there's some. So like we all know as lawyers, if you're going to respond to something, you need to have actual notice of something legitimate to respond to. So there, I feel like you can't just say something that's not true and then I'm supposed to respond to it. But 2 other points I want you guys to respond to. One, the other justice, and I think he was the 4th one down, or it doesn't matter. It's how I kind of was writing in my notes because I couldn't see their names. But he said when he was questioning them, either on rebuttal or he might have thrown it at Gull's lawyer, why, when she was very clear that it's happening right here or it's happening out there and we're doing this now. So what are we doing? Why should we hold that against the lawyers that they didn't go out and do it? Because she was abundantly clear, I'm doing this no matter what. And then my follow-up to that is, even after you guys read the transcript, like the actual transcript, you think she was still trying to help them save face?
Well, that transcript only got released because the defense wanted it released. I think she absolutely was going to do it, let them go, and move on. Now, look, you can question whether or not she really was trying to save face or not. Maybe she's just lazy, didn't want to do the hearing. Maybe she was just trying to save time. I think there was a combination of both. I think she was trying to save time, and she didn't want to dress down these two lawyers in front of everybody, but was willing to do it if that's what we're going to do. My biggest problem is in trying to save a little time instead of, I mean, I'm fine. Give them 2 weeks. Give them a month. I don't really care how long they could have. They could have as long as they wanted. And whatever time she thought she was saving, we've wasted. You know, we've now wasted 3 months where basically nothing happened, and we're back to where we were in October. So I am not happy with Judge Gull and how she did this.
I think she was throwing her weight around, period. And she's still throwing her weight around.
Well, I think she was really mad at these lawyers for what they did. And I think that was justifiable. Maybe she went too far.
I mean,
they released photographs of.
They didn't release photographs.
Look, I have a top secret security clearance. Okay, I have certain responsibilities when it comes to secret information. If I leave that laying on my desk and a friend comes in and takes a picture, or the janitor takes a picture, I don't get to say, "Well, I trusted people. Oh, they betrayed my trust." No, I get in trouble.
Yeah,
but they made a mistake, a huge mistake. This is worse. This is so much worse. No. Well, obviously, you've never had top secret security clearance because most of it's classified as BS. This is photographs of 2 dead girls, one of whom is nude.
Yeah, but Brett,
leaving that where someone could find it is awful. Just say it's awful. You can still think they shouldn't be removed. It's still awful.
Have you ever been to a defense attorney's office in the middle of a trial like this? Ever? Have you ever?
It's not a trial. We're not in trial, though.
That's not the point. They're preparing for trial.
Preparing for a trial.
So we have a war room, and we don't have offices like y'all. We don't have a secretary who sits there in a locked door where when I need to come talk to a prosecutor, I ask the receptionist, they'll call back, and they'll come out and meet me. This is
lock your door?
No. Let me finish. It's a different circumstance. Like you're comparing apples and oranges. It's two completely. When we had Garcia, like we had a war room where we had everything out because it's impracticable to put things away every single day.
But did you let everyone come in there? There's a difference.
And it's also impracticable that if I have to go to the bathroom, that I have to remember to lock the door in my own office. That's not realistic.
It's different to let people walk around. I agree with you. When I'm in the heat of everything, and I had top secret clearance for a decade, you never let someone walk around unaided when you know something is under a protective order.
That's not how defense attorneys
I don't understand why you can't just admit that this was a mistake. I'm willing to admit that Judge Gull made mistakes in how she did this. Just admit that what they did was a huge error that was very detrimental, not only to the families and the victims,
so if your home
but
was
potentially
robbed, so if your home gets robbed,
his office wasn't robbed.
He didn't have an alarm.
His office wasn't robbed. He invited the robber in and said, "Hey, hang out with all the stuff. Don't take anything," and then left.
No.
Like, just admit that what he did was wrong. It's simple. Just admit it.
Is it the same as calling him a leaker? That's my point to you. You said, if I let someone in, then aren't you just you made not a horrible mistake.
Under a court order and under like top secret clearance rules, if you are the source of that leak, because the documents did not come from the prosecutor's office, they did not come from some other person, then yes, you are the leaker. When we get trained, I mean, we have to get trained every like 2 months for top secret clearance. That is absolutely how they define it. And I think that's correct there, because otherwise, how do you stop these from getting out? Are you saying that no additional measures should go back to the way that they practiced before, which is to let anyone come in and be able to have the documents
additional measures? You know, he's okay. Well, I'm going to keep the office locked now, but
yeah, afterwards.
The fact of the matter is that when Westerman went into that office, he was going in as an operative. He had a plan. I don't know if there's a will, there's a way. I don't know what could have been done. Again, it's not a lockdown office in the sense that you guys are used to. This isn't a top security type case. Yes, we never want pictures to be leaked. But here's what I'm trying to tell you is at some point you have to look at, did it affect Richard Allen's trial, his right to a fair trial? And it didn't. You can say that it did. Yes, we're all concerned.
If the prosecution had leaked it, you would say it did.
Well, I'm not.
If the prosecution had leaked crime scene photos.
No, I wouldn't be. No, I wouldn't.
Yes,
be.
you would.
No, I
so you
wouldn't
don't
be.
think if the prosecution released these photos and the jury saw them,
Release?
that
Yeah,
that would have a
somebody's
negative
not-
impact on the jury?
But somebody released. Those are two different things. Did they release
Leaked,
them?
negligently left them on the
Bob's
park
saying
bench,
no one's
whatever you
seen
want to say.
them. He's
You
saying
guys
no one's
realize that this
By the
leak,
grace of God, nobody's seen them, and they're
same
probably
pictures have
still
been
out
leaked
there.
long before Alan was even arrested. You guys realize that, right? That the tree thing was out there long before.
I'm not
Alan
talking about
was
the
even-
tree thing, Bob.
I'm talking about a
the
naked girl.
pictures of the bodies, okay? And we as attorneys have a higher duty. We're not normal people. We have an obligation to the bar, to the law, to the
You
court,
guys
to our
realize that
client,
these are
to
all
the
coming out at
victims.
trial, right? These are
No, they're not.
No, they would
you
never
and
be
I
public.
will
They
never
would
see
never
those
be public.
photographs.
right,
the
just the
courtroom
jury.
will.
The courtroom, which is different than
The
the
jury will. It's
But
not
the
even
ju-
clear that the courtroom will.
The gallery will definitely see them.
No. When we do child
Maybe it
pornography
depends.
cases, that is
Yeah.
not to the gallery whatsoever.
We
This
turn off
isn't
screens all the
pornography
time.
Because the crime scene itself is part of the evidence in the case. They're going to have to show the pictures.
You
The-
can
the-
have
the jury.
evidence. There can be certainly you've had cases where certain highly sensitive information have to do with naked, dead children are not released to the gallery. We
Well, sure,
sometimes
yeah,
go
yeah.
off screen. Well, I'm just explaining it for people who may not have had these trials. We sometimes go completely off screen and hand out paper copies to the jurors to make sure that there's no accidental viewing by the rest of the courtroom, even if we were to seal the courtroom, because there are certain things that even if it's coming out in trial is part of the evidentiary record is not for public consumption. And there are court orders
100%.
surrounding that.
They won't even tender us copy if it's like a child pornography case. We don't even, well, they don't tender it. We have to come in and
Right.
observe it in the office. So yeah, no, 100%. What I'm suggesting is this is a different scenario in that the way that the crime scene looks, and we've all speculated on what it is. We know that now 4 attorneys think that there's something to it. It's part of the evidence. It's beyond just what the conditions of the girls were in. I mean, it's going to have to be looked at.
All I'm
I mean,
saying is they shouldn't be on Reddit. The pictures of those girls dead in that condition
obviously, I
shouldn't be on
agree
Reddit.
on that. Obviously, I don't want the leak to have happened, Brett.
Okay,
It's
well, so then you
shame.
agree with me that
But-
that was a
but-
bad thing. They shouldn't have been removed.
Obviously, it was a bad thing.
Okay,
That's not
we're,
what I'm
we're
saying.
making progress.
I'm not assigning as much
I
blame
think Bob's point
on the
is
lawyer.
that it's
That's what
not
I'm
when you
saying.
said he did a horrible thing. He did a horrible thing. When you put it in perspective, he made a bad judgment call and trusted a friend to come into an area that somehow, some way he gained access to those things. There's not any telling, like he left it on a table. Bob's saying this guy went in with a plan. So if you've got a plan, if you're in my office and you've got a plan, Bob's point was we don't have the doors locked. Now, we would never have pictures like that out, but they're in a cabinet.
Allie,
They're
because
in
you're
a
a good
cabinet,
attorney.
and if you're looking and you want to open it, that cabinet wasn't locked because we never wanted everyone's to go grab a key somewhere that they could find it. So what he did may have had a horrible outcome, but like I used to say, you'd have this stigma, right? Late in high school, if you were pregnant, like talking when we were younger, you're like, oh, I got pregnant. You got a pregnant teenager. And I'm saying, you guys are all doing the same thing that caused her to get pregnant. So why are you acting like she's the end of the world? So it's like you're penalizing him for the outcome when what he actually did wasn't so horrible.
Can I ask this though? I am very curious about this because I know my answer. Have either of you ever been under a protective order by the court and it accidentally, not intentionally, violated it in this manner? I have not.
I have, I guess.
Allie, I'll let you take it.
I have, although I
And that's
argue
fine.
that
I think that's helpful for people to hear. I have not.
Yeah.
And
I mean,
I had an
there
issue
was
where
a trial that was very similar to this. The Garcia case was very similar to this in a lot of ways. The one distinction is that it was in a different jurisdiction, and we were in on a pro hoc vice, which means you apply to the court for a limited license to try the one case. So, and we had to have a sponsor from, Douglas County, Nebraska, in order to try the case out there. So, I mean, It was exceptionally similar in a lot of
But I
different
want to
ways.
explain because it wasn't like this. It was,
Right, it was
we got
different.
material on a corresponding case where we thought that was similar crime. I'm like, found out that there was this other crime that was so similar 3 months before, 3 miles away, blah, blah, blah. So we got it, right?
MO for a strange MO, the MO was the same.
Right. So I gave my expert, and we did have sheets that we had to give to people, like to sign, but I gave my expert the DNA to cross compare the DNA there with the DNA at our scene. And then I spoke on the fact that we got results that indicate a low level of DNA from. So it ended up being the fact that I talked about something I couldn't have known, but for the document that was protected, violated the protective order. So not in the same manner, but
I would say a very different manner.
Yeah.
I would say in a very, very different manner.
I just want to be clear. The leak was a horrible thing. No, leaks of dead, beautiful girls should never get out to the public. Can I just make that clear? What I am talking about is the amount of blame to assign to Andy Baldwin for it. That's what I'm talking. They're two completely separate things. Leak, horrible. I saw there's no how much blame that you guys are assigning to him for that happening under his watch is what we're in disagreement.
Okay, so what do you do?
That's my thing.
I'm really glad to hear you say that. It is horrible because I think a lot of people are really look to you guys for the defense perspective, and a lot of people don't know how to think about it because of the two things you're saying. There's the actual leak, and I'm glad we all agree it's horrific. Yes, it is horrible. So what, we can just sit here and say, this is horrible. Nothing we can do about it. Is that where we sit as attorneys? Is that what the court for? The court can't do anything about it?
We could have sanctioned him in 20 different ways to where he.
So you agree he deserved to be sanctioned. It's just the degree of sanctions.
I think it was and
is that up to the judge's discretion? Real legal question. Is the amount
to sanction him
up to the discretion of the judge? And is there a spectrum of what
until it runs afoul of the Sixth Amendment? Yes, right. Yes, it is. Sanctions were well within play. She could have what they suggested. Dock our pay for a week, which would have been $8,000-$10,000. They would have felt that. That would have been like, you know what? Get it right, knock it off. I'm done with it. You know what I mean? She had an opportunity to do things other than rip them off the case, and to me, and I don't want to get conspiratorial, but when you look at who benefited from the leak the most up until today happened, it was the state.
I mean, you would admit that the defense does not want horrible pictures of victims getting released to the public. That's not.
So we now agree that it was prejudicial to Richard Allen for those photographs to be out, because 10 minutes ago it seemed like you were saying that wasn't a big deal.
He's saying it didn't get out like that. Right.
Only because the people who took them didn't put them online. There were people who received those, that. It was just lucky. It's like driving home drunk. Thank God you didn't run into anybody. It's like Ali was saying about you're doing the same thing, but nothing happened. Okay, well, they didn't make it to Reddit, so therefore not protecting this isn't a problem. I mean, look, I think we all agree that it was a problem. I mean, I totally understand your argument that Judge Gull overreacted, that she went too far, that was beyond her discretion. I do think, look, at the end of the day, I think if Judge Gull was going to take this extreme measure, she just should have had the hearing. And I don't know what would have happened. Maybe the Supreme Court would have said the same thing. I will say this, if she'd have done that.
I'm going to tell you this. The Supreme Court would have said the same thing.
Look, there are dissents in this case. So there's at least some justices who agree that even under this record, they shouldn't have reinstated them. So who knows, with an actual record, maybe they would.
I'm going to venture, I'm going to go out on a limb and say it's because they didn't ask for the remedy of their filing of their appearance to be accepted when they were private counsel. They only asked to get reappointed as the court-appointed attorney. And I suspect when you're court-appointed, the court has a little bit more say because they're the ones literally, appointing you.
No, that's right. That's absolutely right. And you're right.
But again, and that's where I'm saying, I've always said the right to continuity of counsel is not as black and white, although it's there. It's there if you want to find it. And one of the judges said, can we start today? And she said it to the attorney general, who obviously is more forthcoming than if they would have asked Gull's lawyer, that we start with the presumption of the right to continuing counsel. And the attorney general, said yes. But you're talking about they didn't ask for that relief. So that to me is where I'm thinking that they are going, unless it has something to do with the fact that they should never been there in the first place.
Because we actually we had Kara on a live, and we reached out to her. We're like, are you sure you don't want to add that in? Because like she had sent it to us right before it got filed, and like, are you sure you don't want to add that in? And
I was like, what is happening?
Yeah, she's like,
I think y'all really underestimate how much they don't want to be pro bono counsel. I mean, that would be, they'd go to the poorhouse to do that.
I mean, can you imagine how expensive
we know more than
you guys
anybody.
know?
Are you kidding?
Yeah, well, then why do you think they would want to do that?
They didn't
but don't
want
offer to do it.
It's a good, well, it was a good legal sort of
Argument to get into
like it was like a good,
but
what's what I'm looking for, like a public thing. We're so committed, we'll do this for free, but they don't actually want to do it for free.
If the trial would have dragged on for 2.5 years, it would have been suicide for their practices.
It would have decimated their practices.
I can tell you the real answer to that. I'm going to give the real answer to that. At least from what my understanding is from speaking with them, is that, and it was basically what the lawyer came back in rebuttal, because I can tell you when he was asked right then and there, hey, do you want to ask me for some additional relief? You didn't ask me, because I was playing this on mute because I obviously people need to hear it. But I'm back there going, yes, please say it. Yes. And he was like, no. But he came, he sort of
I will say though, I think it's because he read the room after that question. He's, I'm going to win anyway.
Yeah, I don't need to do this for free.
To be totally honest, I probably would have, he knew he was winning. And so he's like, might as well ask for the whole kit and caboodle.
But the real reason that I was told was like, they want this precedent out there so that the judges know you can't even do this. And they felt so strongly that they can't even do this, that they weren't going to pitch them a softball that they could fall back on and be like, we don't have to get to this because you know what? You're not allowed to do this, being the other this being remove private counsel of choice. So that's why they chose not to. It was more of a defense bar move, but they researched it first, obviously, to determine it's in the best interest of the defendant, because they felt 100% with all the people who had researched that they would say they couldn't even do it as court appointed. So that was why they did it.
I mean, I that was only joking aside, but the rebuttal was very clear, saying that it would be a half measure remedy if they had to do it for free. And in reality, we've said this before too. These trials, these investigations leading up to the trial are expensive. Experts are expensive. Absolutely. If they had to do this for free, when they asked to do it pro bono, both of us chuckled because we're like, they can't. They literally can't, because it's too expensive to do it. But I understand your point as to it's not because they're caring about their own bottom line. I would care about my own bottom line. I don't think that's a problem. You need to turn on the lights in your office building.
I like to eat.
I like to eat. Yeah, I like to, drink bubbly water.
Kids,
but I understand you're saying that they're doing it for the legal reason. And also, I think that attorney was smart and read where the questioning was going, and it was already in his favor by that point of the rebuttal. It's always a nice feeling when you get up for rebuttal and you're thinking, I got this bench.
Yeah.
Bob, it sounds like you think no matter what, we're still going in October. They're not going to move for an earlier trial.
I think they are. I just don't think
you think they are. Okay.
Yeah, it's because if the 70, I just think that they're going to wait to figure out what they're doing with their motion to recuse her and whether or not she's going to. And like you guys aptly noted, they need to see the opinion. They can't go in blind on either of those hearings without knowing what the Supreme Court is weighing in on. Because
don't you want to press the motion to recuse sooner than later? Because you got the Franks motion hanging out there.
Yeah, I want to.
You're going to recuse her.
Man, I want to press all of it sooner. It's like you said. I mean, 3 months have been wasted, like where this could have been time well spent, and whether or not they would have gone to trial on the 8th. The one thing that we know, if you've got two lawyers that have been on it for a year, she's not kicking it till October 15th of 2024. If she kicks it to March fine. You know what I'm saying? It's whatever the
now
case.
they get all the, they got to get all the stuff back because they gave it all back. And they got to get it sort of, because I'm sure they had it organized in a way that was easy for them. And I mean, it's going to take a little time for them just to get all that together.
For sure.
And I want to ask you guys, you being the prosecutors, because Bob told, because I said to Bob, well, all right, let's assume they just filed that, they set that motion to get heard for the removal of the judge. And apparently he was told by multiple lawyers in Indiana that there is no method to raise bias. Substitution of judge for cause, in my experience, never goes before the judge for cause. If you want to say a motion to consider recusal, then you're asking the judge, you're saying, Judge, do you think you have a conflict? There's this like little issue over there. So, but Bob said that they don't have a method. And to me, it makes no sense that there wouldn't be a way to file a motion for bias and that motion would never get heard in front of the judge.
So, I mean, at least here, and I guess sounds like in Indiana, the judge decides their own recusal motions. Now, the thing that I wondered is if she denies it, can they interlocutory appeal? Can they mandamus her? I mean, I feel like mandamus, it's funny, in most states, mandamus is a pretty rare thing, but I feel like mandamus is something you can do when a judge refuses to recuse.
That's what they said. When I was sitting at the table, I had the conversation, and that's when it came up. And I was with Lehman and Kara, and I said, well, the recusal motion is still pending. I'm assuming, who are they going to bring in for that? And they're like, what are you talking about? It'll be Gull. I'm like, Gull? I'm like, this isn't a conflict of interest. It's a bias. I mean, it's a completely separate thing. I mean, how could, for us fundamentally, Alice and I were like, wait, how can a judge, of course, they're not going to say they were biased. They're like that.
I mean, does not have something called substitution for cause, where you're asking the judge be removed?
No one used that.
And it's really interesting. It's interesting that I agree with you. It's really awkward when you're making those arguments before the judge. But I mean, in those situations, you almost always know it's going to be appealed, and in some cases, mandamus. And so the judge is cognizant of that. It is an awkward hearing, awkward as all get out, but that is what happens in our jurisdiction as well. So, I mean, it doesn't typically happen that often. I don't know what the jurisprudence is in Indiana.
If I was Gull, I would seriously consider recusing at this point.
Yes. That's exactly. Here's my prediction. My prediction is at the recusal, when that comes, she's going to get on the bench. She's going to say, look, and she's not going to allow them to cast shade on her. She's going to say, look, I've just been appointed. I had some health issues coming into the new year. I've just been appointed the chief judge of a very large county. It's a ton of extra duties. And my docket is packed. I am concerned about the fact of being able to leave my county now as chief judge for 6-8 weeks, however long this trial is going to take, for solid. Maybe somebody can replace. But I think if I'm her, I'm like, what is the benefit for her staying in this thing? Like
it is. I don't even think she has to give a reason, to be totally honest.
That's what I'm saying. She does it.
So I have a judge who had a case for 3 years, and this particular defendant was like really just crazy, not mentally, but like the tactics were exhausting for everybody. And finally that judge was just fed up and recused himself with no explanation. We all knew why. He was tired of it.
See, but in a case like this, like that train has left the station. Like she couldn't do it without saying something. Like in our case, our judge.
Well, you're right. She has lots of excuses.
Well, I mean, it's not even like she does, and she could bow out gracefully. If people are going to snicker, so be it. Who cares? I mean, she's got bigger aspirations. She's tried to get in the high court 3 times, so she wants to get up there, and that's what her end goal is. Like, why torture yourself with this? When
I think she's lost her chance with this.
I don't necessarily know that. I think she's a respected
seemed
jurist.
pretty irritated.
Alice, and I agree with you, though, that I don't think she benefits from
jurisprudence
staying on the case professionally at all, right? Oftentimes you do benefit when you are a judge presiding over a very high-profile case. In this situation, because of all the history, if I were her, I'd be looking for ways to get out.
Get the hell out. I think she just recused herself. But I think she'll wait till that hearing. That's what I'd do it if I were her. I just say, like, you know what? I'm good.
Putting all that aside, I mean, we're all kind of, I guess we're kind of being cynical about why she might recuse. But I mean, I just think as a judge, you now have a very acrimonious relationship between you and the defense attorneys. And look,
Yes.
there are plenty of defense attorneys that judges don't like, right? I mean, they're repeat players that judges have to deal with in every case, and they don't like them. But this has become a very acrimonious relationship.
Oh, yeah.
And you have the appearance issue. I mean, even if she can totally put all that aside and rule down the line on these guys,
Follow the law.
I mean,
everybody's still going to be everything that she rules against them.
Right.
Everybody's going to
They literally just asked for a mandamus to remove her, right? They didn't
Yeah.
get it granted, but they are the lawyers who asked for it.
Right.
And I mean, that
And
appearance is there, absolutely.
Baldwin told me a story that he picked up a murder case in Allen County, and guess who his judge is? So he
Well,
went
there you
in
go.
there. Yeah. So he goes in there, and she wouldn't even look at him. She was like, this is 2 weeks ago. So it's like leading up to it, but it's like
some
it's
states
just an
actually have it where you can force recuse a judge. You get one opportunity.
We have that.
that's us.
You have that?
Yeah. As long like prior to any
It's
kind
a
of
class X2. We can name two. I want a substitution of judge, and
You can
don't
name
give
the
me-
substitute. Wow.
and no.
Oh, no.
And don't give me.
Oh,
These
and don't
other
give me.
judges.
Okay.
Oh,
Right.
I see. Okay.
Huh. That's
We don't get to
And
do
you
that.
have- You have 10
No.
days.
they
you
don't
have
in
to do
Indiana
that.
either.
You have
Got
to
it.
do it
Yeah.
within 10 days of
Gotcha.
this getting on that judge's docket, or before they make a substantive ruling. Once they
Okay.
do that, you have a
So
substitution.
that you can't game the system and whatnot.
Right. Then you have a substitution for cause. And I have gone in on one where it was a civil case. So the client felt that the judge was prejudiced, and that was assigned to another judge. I've never been on one where that judge hears that. But then Bob and I had a case where the judge, so we're obviously in front of all the same judges all the time. So this whole you're in front of the same judge. We have a judge that we're on trial with who literally, and he is the only defense bar judge on the bench in this particular county, but he literally basically called us liars, cheaters, and stealers, like in no uncertain terms, and yelling and screaming. He's, like that, was like quoting off of our website. And then I had a trial in front of him. And then I had to do a trial in front of him not that long after that, right? And it was going to bench. So there was a lot of tension there. And in that trial, we had an issue come up where the family of my client was saying that they were there when they went to do the police interview. The father was in there with them, and I never got any information like that. And so I sort of just put it to the side of my mind, like they're misremembering, whatever they think happened didn't happen. They were so persistent. I remember calling the father on the phone, and he described to me where he drove, not a normal spot, but a spot that they have. And then the mom tells me, I have the voicemail that the cop left me after they left. And it said, he just left, he and his father were here, blah, blah, blah. So anyway, this cop's on the stand, and I'm questioning about this interaction. And I just had the dad take a picture. I'm like, go to where you were and take a picture. So, and I ask him, and then he denies it. And he gets off the stand. And then the judge, he's literally top of his lungs, red faced. And he's saying that am I trying to tell him this cop he is known for 20 years just sat on the stand and lied? Am I about to call a witness to say that? Because if I am, and I can't prove it, he is reporting me to the ARDC, screaming. And then he, of course, says, and if she can prove it, you guys over there are in trouble too. So I'm like, you need to get home.
That's some pressure.
He told me to prove it, right? You need to get home and go through all those old phones and find that damn voicemail, because the world's coming to an end right now. So she went to go find those things. In any event, all of a sudden, the state finds the Miranda warning. The dad's name is on it. He was there. It happened. There was an interview. So a couple of days later, the judge, when the trial's over, he commends Bob and I. Now it's an empty courtroom. It was
Of course.
Right.
Through us in a packed courtroom.
What a delight we have. What a just the bench, the defense bar is so lucky to have us. More people should fight like us. And, to this day, he still loves me. But before that, he had it in his mind that, we are lying. And now he thinks I'm going to put on.
I think with Bob and his hat on, I just have to say, I think everyone in the chat thinks this. It really is such a pleasure to have this conversation with you guys, because I think in a day and age where civil discourse is lost, where we can have different opinions about the law and still be friends and be able to, discuss it in an intelligent manner, is really, we need more of it, not less. So I just wanted to say thanks while Bob is wearing a hat, because why not? And maybe this is a good time to do our wrap ups without having to sign off. Do you guys want to do that?
If only I had a cowboy hat.
We should do it again. Because it was super
we should absolutely do it again.
I was like, wait, do this same
I don't even need this to be
all right, everyone, again.
This was just fun.
Was fun.
Like, I could have done this even if we didn't have people watching us. That was just
so
fun.
we got.
Agreed.
We got the Murdaugh 3-day evidentiary hearing at the end of the month.
Right.
Yeah.
Coming up.
They got slammed, man.
They did.
But
The value of having a hearing.
I just can't get over Bob in his hat. I'm sorry.
Bob, you look
Bob,
good in
I'm
that
going to
hat.
direct a serious question at you. You look fantastic in the hat. I'm a Texan. I love that.
Thank you, ma'am.
Before we sign off on talking about this hearing, I agree with you. I hope we have many more conversations about all types of cases. Is there anything else you'd like to tell us as, the arguments ended and physically being in the court? What the mood was in the court, and any last thoughts you may have?
The mood in the court was obviously like, I didn't see anybody from the families that looked overly upset, because remember, Patties were there, so the families were there. They didn't look infuriated to me. I think, and I hope that they realize, and I've kind of been yammering about this, that this is going to expedite the trial, which I think is a benefit for them. And I think that, if they've got the evidence on Allen and he goes down, then God bless him. Like, they got the guy, you know what I mean? And if they didn't, either way, they need to get to that point where they're not being tortured. This thing's been going on for 7 years. Enough is enough. It would be one thing if Richard Allen's statement hadn't been sitting in a file for 5 years, but the fact of the matter, it was. We can't ignore that. It's much like the things that happened with Hewerman, where they had the first generation green avalanche in the ogre description for 10 years, and they chose to ignore this witness. So from that perspective, just for the families, I want this thing to get moving. It's time. I hope that whatever happens with the judge, whether she's going to stay on, whether she's going to recuse, that the thing can move forward in a truly judicial and judicious fashion, because that's what the families deserve. I mean, it's the way it's got to go down, and this has been a carnival show for long enough. I'm hoping there's going to be some calm in the port now, and that everyone can calm down and just go about their business and try the case. So that was kind of my vibe from it. Ultimately, because of the structural error that Alice and I firmly believe that it would have been, I'm relieved for the families. I think it would have absolutely been tried again. I think that Lehman was on the spot when he said this would be a test run trial, and the families would have to sit through the worst day of their life again and hear it for weeks and weeks on end. Like, the thought of that is absolutely devastating to me. It's unfathomable. Like, I can't even put my mind to a place where I lost one of our 4 kids to something like this. I can't even get there. I can't. Of course, I have massive empathy, but I can't even bring it's so horrible that I can't even enter that zone, So for me, I really want to see this thing get moving along, and
thank you for saying that, Bob. And all 4 of us, we've had good discussion. We've disagreed some, agreed some, but I think you're right. This is now where we are. Let's move forward and get justice for Abby and Libby. It has been long enough, and this is going to be a very interesting ride all through the end of a trial. So I hope we have many more discussions like this.
Totally.
And I just want to say, Bob, I love the quarter zip.
Hey,
Don't encourage
such
him,
great
Bob. Do
style.
not encourage him.
you have
That's great
excellent style as well.
You
my
look
friend.
great, Bob. But don't encourage Brett. He has his big head about
When we
this.
first got on, I'm like, are we matching?
We pretty
All right,
much
before
are.
you boys have a love fest about your quarter zips, Allie, is there anything else you'd like to say before we sign off?
Well, I guess we can't say it now, but we can talk about it later. One of the things I did want to ask you guys is how you felt about the new lawyers basically saying, we've looked at the crime scene pictures, we've reviewed the evidence, and we see evidence of, some ritualistic or Odinistic, whatever the case may be, features being relevant in this case. And maybe it'll be a topic of ours next time we do this, because it's probably too long.
They said it had merit. It was basically, and like they were handpicked by Gull, both of them. She thought they were Allen County guys, Labredo especially. But Scremin wrote that motion, Labredo didn't. And again, you have it's not a PD's office. You got two guys, whatever. Allison, you're supposed to say something else. You're not supposed to engage in another.
No.
Well, I know.
Truthfully, I have it. I think there's.
Say how much you enjoyed hanging with our friends and discussing. Kind of thing.
No, I love her substantive questions. I do agree that would be a great another conversation that I'm sure we'll have.
Right. That's all I was saying. And then I can say it's been
called
great.
a cliffhanger.
Right. There you go.
It's called good TV, Bob.
Come on. This is your field,
Diaries.
buddy.
Yeah.
The prosecutor's diaries.
But this has been great. And I found the Supreme Court hearing, very interesting. I will be interested to read the ruling, even though it won't matter, but I'll want to know what was in their minds and what they've decided. And
I can't wait. Just the law nerd. I'm excited.
I know. I really can't wait to read it. I think it's going to be fascinating the next couple weeks, what unfolds in this case. But maybe we'll have another conversation about it. Well, thank you guys so much for joining us. This has been one of my favorite conversations this year. I know we're only a couple weeks into this year, but it's been a great one so far. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Brief. Here.
Why don't? So she stole the sign. Why are you? Why don't you have a sign?
No, that's we each have a sign. I'm still in Indiana.
You're still in Indiana. Okay.
Yeah, I have a buddy that lives in Carmel, and I just like.
I was about to say that's a great hotel room, but
See, I thought that was your
man.
cowboy hat. I'm kind of disappointed when I didn't find out. It's not.
Yeah, this I was standing at the Marriott, and the fire alarm went off at 5:25 a.m. Like the whole hotel. So, and I was on the 16th floor, and I'm like, do I have to? I'm like, if I don't leave, because I think it's a false alarm, the hotel will be on fire.